Today we are here to talk about the unemployment system. The goal is to connect all of us, all helpers here, those working in the communities at places where people are first turning to for help, and also those who are working in free legal assistance offices. And I want to just take a minute to say thank you all for joining us today. It is really important that we have these relationships and these opportunities to be able to hear from each other what kinds of things from the folks that we are trying to assist. And I want to give a special thank you to the legislative aides that may be on the call here today, both for joining us and also for stepping in at those moments when we advocates are pulling out all of our hair and don't know where else to turn with trying to navigate DUA. So we really appreciate you all being here. And I also want to pause for a second to recognize a very important truth, and that is now, more than ever, we really need each other. We being everybody who's in these community advocacy programs, in the legal services offices, in the legislative offices, we all need to be able to work together and kind of know, where each other's playbook is, what we can do to help each other to try to solve some of these problems, because I am sure you can all relate to the idea that nobody ever comes to me, for example, and the only answer to their question involves a legal process. And very rarely does ever their question involve just getting resolved by one particular community resource. So again, we're here today to talk specifically about unemployment. And partially in jest, I want to offer a moment of silence for in honor of the millions of minutes that you have probably spent in the last year trying to navigate the DOA process in the last 16 months. I don't mean that as a dig to the folks who work at the Department of Unemployment Assistance. It is a bureaucratic beast, and I think we all really recognize how difficult it is to try to administer this program fairly and efficiently, and it is also hard to be on the other side trying to get it to work for folks. I also wanted to just mention that I think we come together. I'm going to guess a lot of the folks are on this call right now because they've experienced some moment of frustration in trying to assist somebody with this process. And I just want to share a quick anecdote. There is a guest at Rosie's place that I had been working for about 6 months or so, trying to access her unemployment benefits. And I have to tell you that by towards the end of that 6 months, every time I saw her name come up on my caller ID, my heart sank and I was filled with dread, because I knew for sure that what this meant was she still couldn't afford to pay her rent, that she was probably still going to be crying, and that the truth was that there was absolutely nothing that I was doing that was making an impact on her ability to get the unemployment benefits to which she was probably entitled. Putting aside for a moment the fact that the obviously much more important issue here that guest still had trouble making her own needs met, I just wanted to, for a second, think about or talk about the drain on your own personal feelings as being an advocate, and how when you sometimes run into systems such as trying to break through DUA, how that can kind of erode your feelings that you're able to be effective. And while this is not a training or a discussion on avoiding advocate burnout, I just want to put that name out there just in case that's something that those of you coming to this also might feel occasionally, because I know that there are definitely days when I feel it more than others, but just to say it out loud so that you're not alone if you also happen to be feeling this way. Today, we've brought together two of our local experts on unemployment, and they are going to unpack all kinds of very useful information for us, from the law and process to some strategies that you might be able to use in working with DUA. What they can't do is offer specific advice to you about particular cases that you're working on, but hopefully you'll be able to glean enough information to be able to figure out where you might be able to find those answers or to connect more directly with those kind of specific resources. We're going to talk some about the general unemployment system and also the specific special protections that came into play once the pandemic started. We're also going to address what I consider to be a very hot topic right now, which is all of the notices of overpayment that seem to be coming out. We are going to hold some space at the end of the presentation for a full Q&A with our experts. So please put your questions in the chat and we'll keep track of them to make sure that they get asked towards the end. The video recording of this event and also the slides, which are packed full of information, will also be available to you after today's presentation. At this point, I'm going to turn it over to my colleague, Emily Leung, again from the Southeast Justice Center, where she heads up the immigration unit there, to introduce you to today's speakers. Emily.
Thanks so much, Jen. As Jen said, my name is Emily Leung. I'm an immigration attorney at the Justice Center of Southeast Mass. And if you're asking why I'm here, it's because I'm part of the Access to Justice Commission and not because I have any specialized knowledge about unemployment. However, we have an amazing all-star panel for you who know everything about unemployment and are going to teach all of us during this webinar and share all of their knowledge with us. So we're very honored today to have with us Hannah Tanabe and Monica Halas to do this presentation. As Jen said, we're going to try to keep questions to the end because they are going to answer a lot of your questions during the presentation, and the slides and everything will be available after. So just a brief bio about our all-star team. Hannah Tanabe has been with Greater Boston Legal Services since 2015 and a staff attorney with the Employment Law Unit since 2019. Since the pandemic, she's shifted her practice to have a greater focus on unemployment assurance, and she co-directed GBLS's UI online claims project that assisted over 4,000 claimants with their UI and PUA claims last year. So just applause for Hannah on those numbers. Hannah is a member of the UI Bond Bill Advisory Council overseeing the UI online overhaul and the UI Trust Fund Study Commission. So we're very happy to have her with us today. And our other co-panelist and another all-star is Monica Halas, also with Greater Boston Legal Services as a consulting attorney in the Employment Law Unit, where she worked for many decades. She's a graduate of UMass Boston and Northeastern University School of Law. In collaboration with her colleagues, individual clients, and client community-based organizations, she's brought systemic lawsuits and legislative campaigns that have included reforms to unemployment insurance system and laws governing temporary and domestic work. She's a member of the UAW and served as a vice president on the Massachusetts AFL-CIO executive board. And I even know that that is not all of Monica's tasks and talents, because she helped us on the immigration side also with some legislative initiatives. So we're very, very lucky to have them both with us today, and I will not hold you up with from hearing from them. So please, Monica and Hannah, take it away.
Give me one moment. Let me just share my screen.
Thank you. Thank you, Rochelle and Jen and Emily. This is Monica Halas speaking. It's such a pleasure to be here. I also want to thank all the folks who do the hard work in the community groups. And as a registered lobbyist, I really want to thank as well, and my heart goes out to all the legislative folks who have really stepped up in a big way to help so many of their constituents with the unemployment system. So we dedicate this program to our dear colleague, Brian Flynn, who was an incredible champion for unemployed workers and sadly passed away last March. And so this is dedicated to him, and we often ask ourselves when we are in a tough situation, what would Brian do if he were here? So next slide, please. So as we launch into this, I'd like you to think about the world of unemployment right now during COVID as having two major buckets. One is regular UI that has been around since 1935. And in addition to regular UI, we'll talk to you about federal extensions to that program during the pandemic. And the other big bucket is pandemic unemployment assistance, a new program for the pandemic, and we'll let you know all about that. So it's those two buckets, although just to make life a little interesting and confusing, of course, there's some overlap between the buckets. But essentially regular UI that you may be familiar with lasts, most of the time it lasts up to 30 weeks, but whenever there's federal benefits or unemployment gets low, it drops to 26 weeks. And there's a weekly benefit amount that's paid, and that's calculated based on what's called the base period, which is generally speaking the 1 year before you applied for unemployment benefits. And in that, there's a calculation of average weekly wage, and then about half of the average weekly wage up to a maximum is what you get on unemployment. So right now, the maximum is $855 plus $25 per dependent child. Child broadly defined to include kids in school up to 24 and kids with disabilities of any age, etc. And that dependent allowance is capped at half of your weekly benefit amount. So in addition to knowing about the base period now, the other thing, and then you've become an unemployment expert, is to know that there's a benefit year. And the benefit year is the 52 weeks after you have applied initially for unemployment. And at the end of that 52 weeks, you have to reapply, even if you've had no earnings or nothing has changed, in order to get the extended benefits that we're going to talk about. The system is administered in the state by the Department of Unemployment Assistance, or DUA, and overseen by the U.S. Department of Labor, now headed by our own former Mayor Marty Walsh. To apply, you can apply online, and we've given you the link, and you're going to get these slides. And there are separate applications in these other languages. They're not integrated into the rest of the program, but at least the application is in other languages. And then you can also get multilingual help by calling this number. But the whole UI online, which is the name of the system for regular UI, that whole portal is available only in English. And we've given you the link so that you can see what you need to do in order to apply for benefits. Next slide, please. So you can apply for regular UI. There's a monetary, as they call it in DUA speak, a monetary eligibility criteria. And that is that you have to have earned $5,400 in gross W-2 income if you apply in 2021. So that's the income in 2020. Or if you had applied in 2020, because of the pandemic, in the prior year of 2019, you had to have earned $5,100. And you'll soon learn about the other program, the other bucket, but you can't apply for that other bucket right away if you've met these earnings requirements. So the 5,400 is an important number to keep in mind. It goes up whenever the minimum wage goes up with a 1-year lag time. So who's eligible? You can be eligible for unemployment if you lost or left your job through no fault of your own. But fault, just like beauty, lies in the eyes of the beholder, right? So I don't know about your constituents or members, but our clients certainly are not at fault. And it isn't your fault if you quit, but you had a good reason for doing so. There was, it was freezing cold or some other thing that your employer did that forced you to quit, or you had an urgent, compelling reason to quit. And you're also eligible, even if you were fired, as long as that termination was not deliberate or you didn't intentionally violate a work rule. So if you're just incompetent or there was a negligent reason, you're good, you're in. During COVID, there are other reasons now. One is that you have no full-time childcare or elder care because of COVID, or you were laid off because of COVID, or you've been quarantined. So all of those are reasons to collect. Next slide. A lot of questions about non-citizen eligibility, and non-citizens are absolutely entitled to collect unemployment. There's always a but, right? And the but is that you have to have work authorization and a valid social security card. So many of our immigrant friends pay their taxes through ITINs, or individual tax identification notices, I think. Those don't work for unemployment. It has to be a valid social security. And again, having now learned base period benefit year, there's a difference in requirements in the base period, the time you are working, and the benefit year, the time you're collecting. So in the base period, you're eligible if you are lawfully admitted for permanent residence, or you're lawfully present to do work, or you are PEUC. What does PEUC mean? It's a term of art standing for permanently residing under color of law. And what that means is you have come forward to ICE, to the Immigration Service, given them your address. In other words, they know how to find you, and they have decided not to come and deport you. So if that's the case, you're here under color of law. Next slide. However, you're not home free, unfortunately, without that work authorization, because in the benefit year, you have to be available for work. And you're only available for work if you have the documents to fill out that I-9 form that all employers require. And that form needs a document that shows identity and a document that shows work authorization. So for example, a social security card that's not restricted. Some of them say not valid for work, but if it doesn't say that, and you combine that with a driver's license that provides your identity, you're good. And whatever documents you submit, and as a non-citizen, you're asked to submit documents, those are verified through this computer system called SAVE, standing for Systematic Alien Verification of Entitlement. If there's a problem with your documents going through the SAVE system, DUA, the unemployment agency, has to give you a chance for secondary verification, another shot. And during this verification period, benefits are supposed to be paid. Next slide. So a new, as if things were not difficult enough during this pandemic with no offices open for people to walk in and go to, no libraries open to use computers, you're left with an English-only computer system. The other thing that happened during the pandemic was criminal enterprises had a field day. And these criminal enterprises got millions and millions around the country, billions of dollars of unemployment benefits that belong to other people or belong to the Social Security numbers of people who never even applied for unemployment. As a result of that, as you can imagine, all the state agencies freaked out and started to have these very onerous procedures to verify identity. And what that ended up doing for all our clients who were totally legitimately eligible to collect was horrifically delay their claims. It was a nightmare. And then they contracted with this company called ID.me, which is a little more user-friendly and has worked very well for English-speaking people. There have been some delays, of course, for people who don't speak English. And in order to verify your identity, you have to end up giving your phone number, email address, social security number, documents. Whenever you're asked for documents in these systems, it's front and back. And then there are instructions, pretty specific instructions of steps you have to follow. And those are all available on the link that we've given you. Next slide. So at the beginning, when I was talking about regular UI, I said that there's also other things available in that bucket. And one of the things is Pandemic Emergency Unemployment Comp, or PEUC. And those are simply just federal extensions to however number of weeks you've gotten on regular UI. And I should have mentioned at the outset, in case there's a question in people's minds, not everybody gets the full 26 weeks. It all depends on the formula, how long you've worked, etc. But however number of weeks you get on regular UI, you get an additional, during the pandemic, 53 weeks of PEUC. And when that was used up, there was another program, federal program. It's actually a joint federal state permanent program called Extended Benefits, or EB, that gave people an extra 13 weeks. Now here's where the buckets run into each other. If you had used up all your PEUC and EB, and we'll talk about this more later, and you have a COVID-19 related reason, you can get pandemic unemployment assistance, that new program, PUA. The total amount of PUA available to folks is 79 weeks, but everything stops. Oh, excuse me, 79 weeks minus any weeks you got on regular UI or on EB, but everything stops in terms of federal benefits on September 4th. It's actually week ending September 4th, that's a Saturday. So the week beginning August 29th, that's the end of all the federal stuff. And the only way you can get additional money from those programs is if you have an appeal pending or something and you are owed retroactive money. Next slide, please. So what happens when 52 weeks has ended after you applied for regular UI? And this is an important thing for people to know because it's not intuitive. And that is, you have to reapply with UI Online, even if you didn't do any work in the past year and nothing's changed. If you did work in the past year, part-time and had some partial wages, DUA will recalculate your weekly benefit amount because the prior benefit year becomes your new base period. It's the period of time you were working. And your earnings will be much lower because unless they were low, you wouldn't be eligible for unemployment anyway. And we'll explain that in a minute. So if you end up with a lower weekly benefit amount, and it can really, really drop, and it's lower by at least $25, and all of this happened after December 27th, you can stay at your higher weekly benefit amount and collect pandemic emergency unemployment comp. We call that the PEUC fix. And so it's very helpful to folks. However, if after December 27th, and the reason you keep hearing that date is that's when the Continuation Act was signed by Trump. And then there was one more act, the American Rescue Plan. But 12/27, if you were still getting regular UI or federal extended benefits after your benefit year ended, then you can't get that PEUC fix. Now, another good thing about getting on PEUC right away is you may have some additional weeks of regular benefits still coming to you. And those will be paid to you after September 4th when all the federal benefits end. And hopefully all this is going to become a little clearer as we continue to go through the slides. Next slide, please. Okay, pandemic unemployment assistance. So this is really cool because for the first time ever since 1935, there's been a recognition that all workers deserve unemployment benefits when they're not employed. So there are 3 groups of workers that now can get it. And group 1 is the really new and different one. And that is non-traditional workers. So we're talking about self-employed, independent contractors, gig workers, freelance, AmeriCorps, Peace Corps, clergy, and workers for religious institutions, a janitor working in a church under regular law, does not get any money when they're unemployed, but now they do under PUA. And full-time, and this piece of information I think is worth the price of admission, even though it was free. High school students who lost their part-time job due to the pandemic are eligible for PUA. Okay, next slide. So that was group one, the new group. Group two, and this is cool as well, is anybody who's used up all their other state or federal benefits, or remember I talked about those wonky monetary eligibility amounts, 5,400 in 2020, 5,100 in 2019. If you didn't earn that much, even though you were a W-2 earner, you're eligible for PUA. And this is the real prize. If you got denied regular UI, they decided that you didn't quit for good cause or some other denial reason, you can either appeal that or you can apply for PUA if, and big if, you have a COVID-related reason for being out of work. And Hannah's gonna review those COVID-related reasons. And then finally, even if you weren't a worker, there are two situations where you can still get PUA. And that is you didn't work, but the breadwinner or major support for the household died from COVID, or you weren't working, but you had a job offer. And because of COVID, that job offer was withdrawn. You're also eligible for PUA. Okay, so reasons you're eligible. Whoops, looks like I'm doing it, not Hannah. So the reasons you're eligible, the requirement was that you have to self-certify every week that although you're able and available to work, which is one of the criteria for getting unemployment, it's not a disability program, it's a work-related program, you cannot work because of one of the following reasons related to COVID-19. And those reasons can be different week by week. So some of the easy, obvious ones: diagnosed or having symptoms of COVID, member of household diagnosed with COVID, you're providing care for somebody who has COVID, your child or another care recipient is out of school or doesn't have care due to COVID, or you can't reach your place of work due to COVID. Next slide. So self-employed, remember that's the new group that's eligible. Self-employed or independent contractors whose work has been severely limited or reduced because of COVID, or the workplace was closed due to COVID, or you quit your job, were laid off, or your hours were reduced significantly as a direct result of COVID. So all those reasons were good until the American Rescue Plan, until January, until January of 2021. And new reasons were added. And those reasons are retroactive. So if you were denied, but you have one of these reasons, it can be retroactive. So you refuse to return to work because it was unsafe. Or you refuse to accept an offer of work because it was unsafe due to COVID. Or you were working for a school and they had to keep, shutting down, opening up, partial openings, et cetera. It was just so variable, and changes in schedule and partial closures. That was a new reason. And then another new reason was none of the above. None of the reasons were the reason that because of COVID, and if you check none of the above, you cannot get an automatic denial. There has to be an exploration of the reasons that you're indicating none of the above. And now I'm going to turn it over to Hannah.
Thank you, Monica. So provided the individual satisfies one of the self-certification reasons that Monica went through, unlike regular UI, claimants are automatically approved for a minimum weekly benefit amount, that's not based on their earnings. And that's $267 a week for a maximum of 79 weeks. Claimants can provide proof of their earnings from the prior tax year in order to boost their weekly benefit amount. And the maximum amount is $855 plus the dependency allowance. And importantly, if you disagree with a decision from DUA regarding the PUA claim, there's a right to file an appeal. There's also a right to file a waiver for any resulting overpayment. And we'll go over some of the disqualifications that are commonly seen, as well as sort of the waiver process. You can apply for PUA either online or over the phone with multilingual assistance. And like Monica has stressed about these federal programs, they are set to expire the week ending September 9th. DUA will take new applications for retroactive benefits for PUA, which will be payable through October 4th. So, once someone has applied for PUA, there can be a number of reasons why they're disqualified and why they might be seeing an overpayment notice. I strongly encourage you, if you're working with an individual, to review their non-monetary determinations in their inbox, because that will give you really helpful insight into what is a possible disqualification or disqualifications on their claim. So the first commonly seen one is the identity verification issue. Like Monica mentioned, there were coordinated, sophisticated criminal enterprises hacking into the PUA program, and that caused a nightmare for legitimate claimants. Claims were being denied or delayed because of the identity verification. PUA does not use ID.me, which is the third-party vendor used to verify identities for regular UI. The process is done through a fact-finding link through the PUA account. And we linked the DUA instructions, which are helpful to review to see what kind of documentation a claimant should be submitting or should submit if they're appealing the issue to try to get it redetermined or resolved. Like Monica also mentioned, there are work authorization requirements for the PUA program, and failure to verify that you have valid work authorization can result in a disqualification. We've also seen disqualifications because of full-time work. With both regular UI and PUA, someone can work part-time and still be eligible for benefits. And there's something, what we call a 1/3 disregard. I think one of the easiest ways of thinking about it is if someone's working part-time and their earnings equal or exceed 133% of the weekly benefit amount, in PUA, that would be, for a lot of folks, the minimum $267, plus 1/3 of that, which is $89, I believe. You would be disqualified from PUA if your earnings exceed that. Then there's also the COVID-19 eligibility disqualification that we're seeing a lot of, and I'll talk more about that in greater detail in another slide. And also the employment substantiation issue, which was a new rule that was created under the Continued Assistance Act that passed at the end of December. So, if someone receives a disqualification from PUA, again, it's really helpful to review notices in their inbox, and it's the non-monetary determinations that you want to keep an eye out for. An appeal can be filed through the online account, and I've kind of tried to help navigate through, from the main page, you're looking at more, ... at the top, and then there's an appeal portal, and you want to copy and paste the corresponding letter ID from that non-monetary disqualification to file the appeal. Claimants have 30 days to file an appeal, and there are limited circumstances outlined in the regulations that we cited for late appeals filed beyond that 30-day from the notice of disqualification. I recommend filing an appeal as soon as possible, and then considering whether you might be able to get the issue redetermined. DUA has a constituent services For the PUA program, PUA constituent services, we've provided the email here. DUA has asked that this email not be shared with claimants, but if you're an advocate and you're working with a claimant who has a disqualification, maybe they just weren't able to upload the right documentation, you can reach out to PUA constituent services to request a redetermination. You want to include the claimant's name as well as their claim ID number so that DUA can look them up on their end. Once an appeal has been filed, a hearing will be scheduled. And once a hearing is scheduled, you can upload additional documentation through the PUA account. DUA has said, even if you're not emailing to request a redetermination, they are reviewing additional documentation uploaded by the claimant to review, for possible redeterminations. It's no surprise that DUA is totally overwhelmed with the volume of claims and appeals that are being filed, and they really are trying to see, can we resolve this issue without having this claimant go through a hearing and not having our review examiners, conduct a 1-hour hearing with something that was just missing a W-2 or pay stubs. Again, another helpful document to review is the appeal case folder that is released in the online inbox once a hearing is scheduled. It will include documents that the claimant uploaded once the hearing was scheduled, as well as their initial PUA claim and the notice of disqualification and the notice of hearing. Another helpful portal to review is the submission sections on the online account, and that will show you a catalog of everything that the claimant submitted for fact-finding questionnaires and documents that they uploaded. And that can be helpful to see, what did they already provide, and how can we possibly supplement this? The hearings for PUA are single party hearings, meaning it's just the claimant and a review examiner from DUA who acts like a judge and is the decision maker. Employers are not present at these hearings. And I wanted to flag a couple wrinkles that we've been seeing at these PUA hearings. We're going to talk a lot about helpful documentation to upload, but review examiners should also be crediting claimants' testimony during hearings. The claimant, may not have an email from the employer saying, we're closing our business on March 15th because of COVID-19. Or, if they're an Uber and Lyft driver, maybe their rides and business went down because of the stay-at-home order, but they're not going to have something in writing. There's not going to be a smoking gun, right? But the claimant should be able to testify to, for example, how COVID-19 impacted their work. Also, review examiners, if the claimant is being represented by an advocate at the hearing, should be asking questions, about admitting exhibits into evidence to the advocate. Review examiners should also not be swearing in advocates. Advocates are not a witness. They should only be swearing in the claimant and maybe any additional witnesses that the claimant brings to the hearing. The COVID-19 eligibility disqualifications and hearings. So we are seeing a lot of folks get these non-monetary determinations and say, you failed to satisfy the program requirements. And it does raise serious due process concerns because the notice doesn't really say much more beyond that. And it leaves a lot to the imagination of, well, how do I not meet the eligibility requirements? And going back to the statute, a covered individual for PUA is someone who is not eligible for regular UI, that they have some COVID-19 related impact to their work in Massachusetts or their pending offer of work in Massachusetts, and but for COVID-19 are otherwise able and available to work. Again, while review examiners should be crediting claimants' testimony, it's also always helpful to provide documentation when possible. And we've kind of outlined a couple of categories of possible evidence or documentation that you may want to think about and help a claimant collect in order to either submit for their hearing or even possible redetermination to hedge off a hearing altogether. So proof of employment or a pending offer of employment in Massachusetts, that can look like pay stubs or the W-2 or 1099. Again, showing that it was in Massachusetts, you want the employer's name and ideally a Massachusetts address. an email or a letter from the employer offering work or rescinding that offer of work because of COVID. And if there's no email or letter, possibly tracking down the employer to get an affidavit saying, we offered work to this individual on this date and had to withdraw the offer because our business closed due to COVID-19. Again, the proof of how COVID impacted the work, that could come from an affidavit or letter from the employer, but also if someone had to stop working because their child's school closed, that could be the letter from the school district about closures or the daycare closure. If someone stopped working because of their fear of COVID, either because of their own underlying medical condition or risk factors, or a family or household members' risk factors, consider getting a letter from their healthcare provider to support the diagnosis that, puts the individual or household or family member at higher risk of developing severe COVID. And again, this documentation can be uploaded through the online account in advance of the hearing. And then the other disqualification that we have seen a lot, and I think is resulting in a lot of these overpayment notices, are the employment substantiation rule. And this was a new rule. So when PUA was first propped up, it was, in the midst of the COVID-19 crisis and in an effort to get benefits paid out as quickly as possible, claimants were required to satisfy one of the self-certification that Monica went through. And when the Congress passed the Continued Assistance Act that was signed by President Trump on 12/27/2020, they said, you know what, when we're going to extend PUA into 2021, we're going to require folks to provide proof of their employment, their self-employment, or their pending offer of employment before they applied for PUA. And we certainly recognize and appreciate the challenges that come with trying to get this documentation now, right? Well over a year after many folks had to stop working because of the COVID-19 crisis. We also recognize how challenging it is for folks in sort of the informal, casual labor market that we often are working within legal aid. The PUA instructions encouraged folks, if you were paid in cash, to apply for PUA. And we're finding now, if you were paid in cash, that makes it really hard to substantiate your employment. I do want to flag, if folks did provide documentation for their income verification to boost their weekly benefit amount, they should have received a notice that they satisfied the employment substantiation requirement. DUA was giving folks until July 1st to provide this necessary proof. And then again, if you're claiming retroactive PUA after 9/4/21, you have to provide this documentation within 21 days. Again, I strongly encourage folks to help claimants review notices that they received for relevant deadlines. What type of documentation is sufficient for the employment substantiation? And I wish we had a definitive answer. We ourselves are watching, these claims play out in real time. And I think this is when creativity is great to exercise. I'm also taking the approach of throwing spaghetti at the wall and seeing what sticks, and that, not counting on just one pay stub or one W-2, but really thinking about, what can I prove to show that this person was working or had pending offer of employment and that the employer was legitimate. So we, have listed out some examples. DUA also has examples of documentation to provide. I want to flag that we've had clients who may have submitted a W-2 or a 1099 form and are getting disqualified for not satisfying the employment substantiation request. And from what I can gather is that DUA is verifying the business or the employer by looking up the federal identification number with the Secretary of State. And unfortunately, not all employers are registered with the Secretary of State, and that can be for totally legitimate reasons. Sole proprietors are not required to register. And if that's the case, if you look up the employer or business in the Secretary of State's website and they're not, you can't find them, Legal advocates, you may be able to do a public record search through Accurant or Westlaw to pull a comprehensive business report that you can show the legitimacy of the employer, but also getting creative with Yelp reviews or the Facebook pages of employers, or Google searches and articles maybe that come up with the business or business licenses. For self-employment, that might be the 1099, that might be business licenses or tax returns, business receipts, also affidavits from an individual, verifying their self-employment. If someone was planning to commence self-employment, what were their business plans, licenses, or lease agreements, to help show that they were taking steps to start their own business, for example. For folks who had a job offer that was withdrawn because of the pandemic, letters or an email of offers, trying to go back to the employer to get an affidavit. Again, if you can get the name and contact information, that would be ideal. And again, there are challenges with folks who are paid exclusively in cash. We suggest submitting an affidavit on behalf of the claimant or from a third party or the employer who is paying them in cash. I think what we are also seeing a lot of is folks who may not have been working when the pandemic hit, applied for PUA because, let's say they were looking for work and they couldn't, secure work, and they couldn't secure a job because of COVID, but also their kids were home from remote schooling. And unfortunately, if someone wasn't working and didn't have that necessary workforce attachment pre-COVID and didn't have a bona fide job offer with a scheduled, start date of employment, they may have mistakenly applied for PUA. And in those situations, a waiver for the resulting overpayment is probably the best course of action. The time period, for when are we looking at this documentation that we have to submit? That's really from the start date of the claim or the effective date, going back to the prior or applicable tax year. So if you applied in December 2020, you're looking at the applicable tax year of 2019, and you want to submit some proof of that employment that you were doing from the beginning of 2019 until the effective date of the PUA claim. This is really a snapshot in time of that relevant period. So pay stubs or the W-2. And again, I encourage folks to be creative in what additional documentation they may also be able to provide. Failure to provide sufficient documentation for the employment substantiation request will result in an overpayment for benefits paid after December 27th, 2020. And again, you can appeal the denial and you can seek a waiver for the overpayment. Switching gears a little bit, I do want to touch on the mixed earner unemployment compensation, or MEUC. This was an additional federal benefit that is available for folks on regular unemployment insurance. So as Monica said, your weekly benefit amount for regular UI is based solely on W-2 earnings. But that really left folks, who may have had mixed W-2 and 1099 income with the fuzzy end of the lollipop, because if they satisfied that 5,100 or 5,400 W-2 threshold earnings, you have to start out on regular UI, and your weekly benefit amount is only going to be based on those W-2 earnings, even if you were also driving for Uber and Lyft and maybe made significantly more income, 1099 income. So MEUC says if you can provide proof of at least $5,000 in net earnings from self-employment, that you get an additional $100 a week on top of the weekly benefit amount for regular UI. And again, this applies for folks on regular UI or receiving the federal extensions for regular UI, including PEUC or the extended benefits EB. And again, if it couldn't be more confusing, this is an addition available for regular UI, but you're applying through the PUA portal, and we've linked to that here. Now I'll turn it back to Monica.
Thank you, Hannah. So we've talked about the two buckets and the kind of proofs that are needed and the number of weeks. But in addition, what happened during the pandemic was a recognition that unemployment benefits, particularly for low-wage workers, are way too low, and that enhanced benefits were necessary. From the period of March 29th of 2020 to July 25th, there was an extra $600 a week of federal pandemic unemployment comp. Don't you love all these terms? They all sound like one another. Just to make it even more confusing, this is FPUC. And if somebody, for some reason, didn't get the benefits then because they were mistakenly denied, there are retroactive benefits available. When that expired, there was a new program called Lost Wages Assistance, and that was $300 a week added on from July 26th until September 5th. And because that was paid through FEMA, there's no more money available to make up if somebody lost out on those funds. Then from the signing of the Continuation Act on December 27th, and then continued through the American Rescue Plan, there is an additional $300 a week for everyone getting unemployment. That means even if you get $1 of unemployment benefits, you get that extra $300 a week, and it does not count against SNAP. Back benefits are available. And as Hannah just said, you can also get an additional $100 a week if you fell into that mixed earner category. But as we've said before, all these federal benefits end on September 4th. You may hear the date September 6th in the news because that's what the statute actually said, but they always go back to the ending date of the particular week before the statutory date. And Massachusetts ends a week of unemployment on Saturdays. So that's why September 4th, which is a Saturday, is the relevant date for this. Next slide. So in addition to all these requirements of just getting on the benefit, you have to keep certifying every single week that you are eligible for these benefits. And you have to report your earnings, and that certification has to take place within the United States. They have computer programs to catch if somebody is certifying from another country. And we talked about partial earnings before, and as Hannah said, 1/3 of your weekly benefit amount will not be counted. And then after that, you get a dollar for dollar deduction. And if you're earning 133% of your weekly benefit amount, you're no longer eligible. That's another reason why that PEUC fix was so important, because if you had a higher weekly benefit amount and partial wages, and your weekly benefit amount would drop, then those partial wages might kick you off unemployment altogether, and you won't get the enhanced benefit of the extra $300 or $100 every week. So the other unfortunate thing is those extra benefits, the $300 and the $100, are not used in calculating the disregard. So the disregard is just based on your basic earnings, 1/3 of your weekly benefit amount, not counting the FPUC or the MEUC. And you can certify online through the UI online account or on the online account through PUA. Next slide. So in addition to certifying online, you can also certify by the telephone. For regular UI, we've given you the phone number, which is also automated in Spanish, Portuguese, and Cantonese, but our friends who speak those languages say they're very difficult to understand. Telecert is available every day. And for both regular UI and PUA, you can call this number, the 877 number, to get multilingual assistance. And we've also given you the links to the certification instructions that are available in other languages. And there's also IVR for hearing impaired individuals. Next slide. So during the pandemic, because obviously there was no desire to have people out and about looking for work, the work search requirement, which is another requirement for ongoing unemployment eligibility, was suspended, but that was reinstated effective the week of June 13th in Massachusetts. And this requirement applies to everyone. And the important thing to remember is it even applies to those who have a COVID-19 reason for not working if they're on PUA. So that lack of childcare, or if they're on PUA or regular UI, I should say. So lack of childcare, thanks to the legislature, is still a reason for for refusing work. It's not a reason for not engaging in work search. And the only program that gives some flexibility, although frankly, we haven't seen what that is the PEUC program. That's the extension on the regular benefits. Next slide. So before I just talk about this, the work search requirements are actually not onerous. I'm not sure if oh, good. Thanks. So the work search requirements require you to complete at least 3 work search activities. So that's going online, preparing a resume, etc. And it's advisable to keep a log of what you're doing in case you're asked for it by DUA. There's a model log that comes up on your claim and also on the website. You don't have to use that, but you do need to keep track, date what I did 3 times a week. And okay, thank you. So one more requirement, there's so many requirements when you are getting unemployment, and that is that you go to a reemployment seminar and in-person seminar, and those were also waived. They're run through the Mass Hire Career Centers. And if you don't go to the seminar when asked to do so, it could delay your benefits or even stop them if you don't have a good cause reason for not going. So important for clients, once they start these up again, which we hear is going to be pretty soon, to schedule an attendance after hearing from them, or point out a good cause reason that you can't go. Next slide. So under non-pandemic times, if you refuse suitable work, you are denied unemployment. But for PUA during the pandemic, you could refuse a job and still get benefits for all of these COVID-related reasons. So again, symptoms or coming into contact, or the employer is violating safety standards, or you're caring for a family member with COVID, or full-time school or summer camp. So there's nothing available for your children, or you were told to quarantine. Next slide. So that was PUA. For regular UI, for that bucket that includes the extension of PEUC or the extended benefits, again, you have to be able and available and actively seeking work that is suitable. And one important exception is that an individual with disabilities only needs to be available for part-time work of at least 15 hours that makes a reasonable accommodation for the individual's disability. So right now, the reasons, the COVID-related reasons that you can refuse work and still get benefits on this regular UI side is if there's a reason, again, due to COVID, that you're at risk or a family member is at risk, or sending a child to in-person full-time school, even that's available, if it's available, would put your child or a family member at risk. And work is not suitable if it doesn't accommodate your need to provide full-time caregiving responsibilities. And the governor wanted to rescind that reason, and the legislature, as it has on many times, stepped up and got a law passed to make sure that while the federal programs are still available, that means until September 4th, and requiring 30 days notice to claimants, that these policies are still in effect. And I'm going to turn it over to Hannah now for a really important discussion about waivers of overpayments that you keep hearing us say.
So I know that there are a lot of questions around, waiving an overpayment. The good news is that there is actually a waiver process in place now. Last year when PUA was first rolled out, they said no waivers for overpayments. If someone disagrees with the disqualification that resulted in the overpayment, it's great to file a timely appeal for that underlying disqualification, but also you have the opportunity to appeal the notice of an overpayment, and there's 30 days to do that as well. DUA is not forcing folks to repay any benefits until you get the final agency decision, so you've exhausted your appeal rights and were denied a waiver. For the appealing an overpayment, it's the same as appealing any other disqualification on PUA, where you're copying and pasting that corresponding letter ID. If someone has appealed the underlying disqualification that caused the overpayment, you don't have to file another appeal of the overpayment notice. The wording on these notices can be pretty confusing, but if someone didn't file a timely appeal for the underlying disqualification, they should file an appeal of the overpayment notice, and DUA has told us that that appeal will relate to the underlying issue that caused the overpayment. And if you win at the hearing, or if the underlying issue is redetermined and you're found eligible for PUA, provided there aren't other disqualifications on the claim, the overpayment will resolve and the individual will be eligible to continue receiving benefits going forward. So the waiver applications for both regular UI and PUA can be done online. A waiver for both regular UI and PUA are available if the overpayment was not a result of the claimant's fault, and they satisfy one of these three prongs. So either they used the benefits for some kind of out of ordinary expense, whether like purchasing a car or paying off debt or credit card debt or loan that they may have had that they wouldn't have otherwise done, but for getting the regular UI or PUA benefits, or they gave up some other right or benefit because they were getting the unemployment benefits, like welfare benefits that they may have been eligible for. Or a waiver would be allowed if the claimant's income is less than their expenses. And there's a presumed eligibility for claimants who are on SSI or SSI coupled with SSDI or EAEDC. They're presumed eligible for a waiver of any overpayment of unemployment benefits or PUA. And DUA can, take collection action like scooping tax refunds, but if a waiver is filed within 15 days of the final decision, that prevents DUA from taking any collection action. And like I mentioned, filing an appeal for the overpayment notice, if an appeal hasn't been filed for that underlying issue causing the overpayment, the appeal for the overpayment notice should relate back to that underlying issue. And so DUA may be combining hearings, on the underlying issue that resulted in the overpayment, as well as the waiver denial, to help speed up the process in processing claims. And I also want to just mention the waiver application I've found is really helpful to go through it once with a claimant to try to kind of collect the necessary information that you'll need. And then with both regular UI and PUA, you have the opportunity to upload supporting documentation. Again, we're watching this play out in real time, so I wish that we had better answers for you, but I think it is helpful sometimes to err on the side of caution and upload supporting documentation. So if someone is claiming, X, Y, and Z as expenses, to also provide supporting documentation showing their rent, showing their utilities that they are responsible for every month, or, a debt or loan that they have that they're making monthly payments to. And again, those supporting documentation can be uploaded with the waiver application. And I think running through the application once in order to kind of identify what documentation you may be able to collect and upload in support of the waiver application can be helpful. Both UI and PUA are considered taxable income for state and federal taxes. DUA issues a 1099-G form. For regular UI, that can be requested online. For PUA, you can call to request the 1099 form. And then there are federal and state exemptions from taxes, for the first $10,200. Again, depending for federal taxes on the adjusted income of the individual or married couple. And then for state purposes, it's 20% of the FPL. And then taxes were due May 17th, I'm sorry, this year, but DOR is prohibited from charging any assessments on the failure to pay state taxes on UI received last year. We did want to highlight the Moreo decision. This was a lawsuit that was brought by Community Legal Aid last year, and it resulted from these inexplicable holds that people were seeing, after they applied. There was an issue pending and they weren't getting paid out benefits, or maybe they had been receiving benefits and all of a sudden there was a hold and there was some issue that was pending that needed to be adjudicated. And the Worcester Superior Court ordered DUA to make determinations on new claims within 30 days, to provide notice and an opportunity with an interview before stopping benefits, and to stop recovering overpayments until a claimant exhausted their appeal rights and there was a final DUA decision. And we are seeing some of these delays again, like Monica mentioned, when the benefit year expired, you have to reapply, and sometimes those separation issues are pending again and have a hold on the account. So we did link to the CLA webpage that hosts more information about the Moreo lawsuit and relief available under it. CLA also has a Google form where claimants can fill it out, or advocates can fill it out on behalf of claimants. If there's a hold on the account, and they're just waiting for a decision and they've been waiting for weeks and weeks, CLA is forwarding those names over to DUA to get things processed. And then I did want to highlight, we've talked a lot about the dysfunction of the current UI system, and it was due for an overhaul before the pandemic hit. And unfortunately, March 2020 came and we were stuck with this dysfunctional English-only desktop computer required program. But there is, DUA is actively overhauling the UI system with input and advice from an advisory council. Myself and Stephanie Heron-Rice from Southeast Mass Justice Center are the two legal aid representatives on the council, but we also have representatives for various stakeholders, for LEP claimants, for claimants with disabilities, as well as employer representatives. And as part of this process, there are opportunities for stakeholder feedback, and we've, Stephanie and I have included our emails so that, if you do have suggestions or comments, to please let us know, and we will get back to you as soon as possible and incorporate, the feedback to the extent that we can. And then very quickly, we have a resource page. Certainly couldn't answer or provide everything you need to know about UI and PUA today, but we have linked to helpful resources to refer to after today's presentation, and the slides will be available after today as well. So we do have some time. We almost kept to time, and we do have some time available for questions.
Thank you both so much. And thank you everybody for putting your questions in the chat. I think that what Emily and I will do is just go back and forth trying to read them, and hopefully we can get through as many of them as we can. The first question is that when someone appeals their case, how long should it take to get an appeal hearing? Do you have any sense? Somebody was saying that they had a client who was waiting for more than a month to get a date. Does that seem normal, or what should they expect?
So I know that this was true for regular UI, and I don't think it's also the case for PUA, but DUA was not scheduling hearings for regular UI disqualifications unless a party requested it. And so I think if someone has appealed and is waiting for a hearing, I would strongly encourage them to call DUA to request a hearing. I think with PUA, they are scheduling hearings without a request explicitly being made, but it doesn't hurt to also call. That being said, I also recognize the lengthy wait times that people experience on the phone. And I always suggest calling first thing in the morning to try to avoid sort of an unnecessarily long hold.
Thank you. Let's see.
Another question that came up was, I think that you went over this, but just we want to make sure to capture all the questions that we can. Do we know when benefits will run out? I think I might even know this one. And then is there somewhere to direct businesses who have questions about unemployment?
So in terms of the former question, the federal benefits run out September 4th. Depending on how many weeks of regular benefits you got, or if there's new reason for unemployment, that could extend beyond that date. There's also, believe it or not, we try not to overload you with too many things, but there is another way of getting an extension, and that is if you're on regular UI and you are in an approved training program, you can get an extra 26 weeks on unemployment. We watch the space at masslegalservices.org. We'll be putting together some further information for folks what to do when all the benefits stop on September 4th. In terms of the question about employers, there's various employer organizations that provide useful information to their members. One of them is the Associated Industries of Massachusetts, and they are very familiar with unemployment law. So I would recommend that any employer group contact that organization.
Thank you.
Thanks, Monica. The next question is one of a couple of questions about trying to get retroactive benefits. This particular one talks about somebody being denied for PUA based on providing insufficient evidence of their identification. And is it too late to appeal now to try to get the retroactive benefits?
I think, Monica, correct me if I'm wrong, but if it is just a matter of not submitting the correct documentation and the individual is able to provide it to cure the disqualification, it should be, DUA should be redetermining that. They shouldn't be prohibited just because the 30 days have elapsed. But Monica, please correct me if I'm wrong on that. Oh, wait, and you're muted now.
Sorry, I think that's absolutely right. If it's a fundamental question of identity, they will take it. Of course, the question is, how do we get to them? And I hate to put even more than already exists on the plates of the legislative aides who have kindly joined this Zoom as well. But very often we find the only way to break through is through the individual state rep or state senator, because they have a direct line into DUA. And if it's just a question of moving something along, they have been enormously helpful in accomplishing that.
I think that there was already a back and forth in the chat on this, but I think it might be helpful for others to know. For applicants who gave up on being determined for for the verification process for PUA eligibility, it is not automatically checked with DOR or IRS regarding their records of employment, correct? And so they need to submit the W-2s, 1099s, tax returns, or other evidence related to their employment. Is that correct?
Yeah, with regular UI, DUA verifies wages with DOR, but there's no interagency verification for PUA. And so claimants do have to proactively provide that documentation.
The next question is, can individuals who should have been eligible for either regular unemployment or PUA but never applied, is it too late for them to apply now, even if they're back to work?
So I'll start with PUA because I think that that's a little easier in that you certainly could apply for PUA now. The issue is that you wouldn't be able to backdate the claim any earlier than December 6th, 2020. And that was this wrinkle and rule under the Continued Assistance Act. But with the weekly certification, and because there isn't a corresponding base period that someone's weekly benefit amount is based on for PUA, it's probably easier to apply now if they may not have last year. The caveat being that they would be limited to a start date of December 6th, 2020. With regular UI, what gets tricky when someone is delayed in filing is that it affects the base period that DUA is looking at to determine their weekly benefit amount. And if someone has been significantly delayed, they may not have enough W-2 wages in that base period, the 12 months preceding them filing, to establish monetary eligibility for regular UI. That being said, you can request a predate, which is a fancy way of saying like backdating your regular UI claim, and there isn't a similar limitation of a December 2020 date for backdating a regular UI claim. Often if there's a language access handle, that can be really helpful in backdating a claim, or if someone separated from employment and their employer didn't provide them with written notice of their rights to regular UI, that's a statutory automatic basis for having the claim predated.
Thank you.
There was another question about applying if you hadn't applied previously, but I think you already covered that in that response. So thank you, Hannah. There was another question about someone who was waiting to be recalled to work who was on furlough. And I think Monica answered this in the chat, if they were subject to the work verification requirements still. So can you just address that issue?
So I think the question was whether they have to do work search, and there were a number of regulations and policies that DUA put out because of the pandemic, saying that if somebody is on furlough, as long as that person keeps checking back with the employer, so that when a job is available, the employer will be easily able to contact that person, they should be good. But as I put in my chat answer, and Hannah, you may have an opinion on this, I'm concerned that that policy may also end September 4th. But we'll see, because again, thanks to the legislature, when there was this effort to get rid of caregiving as a good cause reason for refusing work, additional language was put in that said, if DUA is going to deny or cut back or do other bad things to people's benefits, they have to give people 30 days notice in their preferred manner of communication and in their preferred language. So if this is going to take effect September 4th, we're going to be looking to see what they have done August 3rd in terms of notification to claimants.
ask Monica just a follow-up question to that? When you say a preferred method of communication, I've worked with a number of women through Rosie's Place who are very uncomfortable with the online portal or who just flat out refuse to use it because they're afraid of identity fraud and things like that.
Sure.
So what does that mean for those folks looking for assistance?
So there's one thing that was done often to the claimant's detriment actually was for people who didn't speak English and were they would get notifications by mail, by snail mail. And Hannah, did you want to add to that? No. Okay. So and unfortunately they don't text today. PUA. I'm going to defer to Hannah on the rest of this.
So my understanding is claimants will get an email, and I think in some cases a text message alerting them to a notice in their online inbox, but the text or email wouldn't have any substantive information. And so I think the two main methods of substantive communication are either notices through US mail or the electronic notices. And I think what's challenging, especially on regular UI, is that it's very difficult to open the PDFs from a tablet or a mobile device. It really is desktop reliant. With PUA, I think it's a little bit easier to open the notices, but my understanding would be that if someone isn't comfortable receiving, with using that, then they would be stuck with the US notices, which is difficult if someone is in shelter, obviously, or transition. That's, yeah.
Thank you. This question may have already also been answered in the chat, but I think it's worth repeating, and that is about the Mass Hire Career Center requirements for limited English proficient claimants. Is there any exception to them having to do that, or how is that being handled?
Yeah, so the mass hire centers have been trying to be more responsive to limited English proficient individuals. There are multilingual seminars. If you go online to the Mass Hire Career Center site, it also lets you know which languages are available at which career center as well. So there are efforts, but if there is nothing available for you once you get to the career center in your own language, that's certainly a good cause reason for any further non-participation.
The next question asks if you could talk more about what type of collection actions that DOA takes for overpayment cases.
My understanding is, the tax refund that someone may be eligible for could be intercepted. I think right now there's a little less concern about that because hopefully people have received their refunds already. One question mark is about the child tax credit. We're not sure if that would be up for something that DOA could collect on.
Right, and just to add to that, and that's one of the reasons why it's really important once a overpayment has been established. So either finally established for somebody who's appealed, or if for whatever reason they're not appealing or lost their appeal, to file a waiver within 15 days of that decision, because that stops any collection action while the waiver process is going through. And if somebody is denied a waiver, there's an appeal route for that as well. So to protect money, it's a good idea to file that waiver request within the first 15 days of the overpayment if you're not appealing.
Monica, if somebody misses those deadlines to appeal the overpayment collection, is it is it too late for them to try to get a waiver if they've already started doing some kind of collection?
No, the good thing about waivers is you can ask for a waiver at any time. If you've missed that 15 days after the overpayment has been established, then anything they've collected, even if you win the waiver, they won't pay it back. But yes, you can apply for a waiver anytime. And the good thing too about the notices of established overpayment is if you appeal, even though you haven't appealed before when the overpayment, when there was a reason asserted for the overpayment, this clock starts the appeal clock running again, and you get that 30 days from the time of the established overpayment. And I have to say, as Hannah said, DUA is just swamped with cases, overpayments, et cetera. So they want to resolve things as easily and quickly as possible. And they're being very good about waiver requests and granting waivers.
I also want to flag, for regular UI, you can file a waiver. You can also opt to repay an overpayment, and there are repayment plans that folks can enter into. In looking at the PUA accounts, I don't think that DUA has programmed that yet and implemented sort of a repayment plan for PUA overpayments, but my understanding is that should be available to folks, if they are not if their waiver application isn't allowed, or if they, for whatever reason are opting to repay the overpayment.
Looks like we have exactly a minute left. So I just want to ask one question, and that is, have you heard anything about DUA starting to open up their offices for people to be able to come in and talk to somebody face to face again anytime soon?
Yes, they're definitely planning that. And it's very much in the works. I believe they're doing a pilot reopening first to make sure they do it well. We have been told they're going to refigure the entire process and that it'll be much more user friendly. So fingers crossed on that. And I would guess that we will hear what the plan is within the next couple weeks.
Thank you. It looks like we are out of time. It is 3:30 now. Thank you so much to both of you, Monica and Hannah, for helping us through all of this. And I'm sorry that we did not get to everybody's questions, because I know that there's still a good number of questions in the chat that we did not get to, but we really appreciate your time. Perhaps we can take note of what those questions are and get some answers back from you guys that we can send out to the folks that are on the call or who signed up for the call, so they can get the answers to those questions later.
Yeah, absolutely.
Okay.
And this is a good time to remind everyone once again that the slides will be available. They'll be sent out by email to folks who registered, but also posted online on either Mass Legal Services or masslegalhelp.org. And this wonderful presentation will be recorded and posted as well, so you can go back to it for reference as many times as needed to wrap your head around these UI benefits. But thank you so much to our panelists for their time and their expertise. And thank you to all the participants with their questions. We'll follow up with more information after.
Thank you.
Thanks, everybody.